We will go back on the record and we'll go through the first two docketed items. Docket number 2019-014, cause number C/007/0045, request by the Utah Division of Oil, Gas, and Mining to forfeit the reclamation surety in order to complete reclamation of the Wellington dry coal cleaning facility. That matter has been dismissed without prejudice. Correct? Yep. Okay, I got that right. The second docketed item, docket number 2022-010, cause number 070-05, in the matter of the request for agency action of Urban Oil and Gas Group LLC for an order modifying the board's order entered in cause number 241-09. As I recall, that one has been withdrawn. So those two items are not before the board this morning. We will move on to item number 3, docket number 2022-011, cause number 470-06, in the matter of the request for agency action of Uinta Wax Operating LLC for an order, 1, modifying the board's order in cause number 131-151 to reduce the north/south drilling unit boundary setbacks from 330 feet to 100 feet and the east/west drilling unit boundary setbacks from 560 feet to 330 feet for the drilling units comprised of sections 17 and 20 and sections 18 and 19. I won't read the rest of it. That's what we're hearing. At this time, we'll take appearances of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of the petitioner, Uinta Wax Operating.
Trevor Gruelle with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Thank you. I guess at this time, we'll turn the time over to you, Mr. McDonald.
Thank you, Chairman Hansen. Members of the board today that will be testifying on behalf of Uinta Wax virtually thanks to the board's order will be Ms. Whitney Womack. Whitney, would you please wave your hand? She is the landman for Uinta Wax LLC. Ms. Meredith Roberts. Meredith, would you raise your hand? Okay, thank you. She's the geologist of Uinta Wax LLC. And Ms. Brittany Hasselback. Brittany, would you wave your hand, please? She's the senior operation engineers of Uinta Wax LLC. All of those share the duties with the petitioner. I would ask that they be sworn as the witnesses this time.
Would you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, do.
Mr. Chairman, the resumes of the witnesses were collectively submitted as Exhibit A. If asked, each will confirm the information reflected in their respective resumes is true and correct. Ms. Womack will be a fact witness only. Ms. Roberts and Ms. Hasselback are testifying for the first time in front of the board, so we will qualify them as experts in geology and petroleum engineering respectively at the commencement of their testimony. Also want to just confirm that, again, it's acceptable to move for admission of all of our exhibits at the end of our presentation to Chief.
Yes.
Thank you. Members of the board, today, Uinta Wax is once again before the board seeking reduction of the setbacks from 330 feet to 100 feet heel toe and from 560 feet to 330 feet perpendicularly for long lateral horizontal wells, this time on the drilling units comprised of sections 17 and 20 and 18 and 19 respectively of Township 3 South, Range 2 East, and also to create special overlapping drilling unit comprised of all 4 sections for internal unit boundary wells. This requires modification of the board's order in cause number 131-151, which established the sections 17 and 20 and sections 18 and 19 drilling units with the larger setbacks. Similar relief was granted by the board for the entirety of the township located directly west of these lands in the board's order entered in cause number 47003 as modified by the board's order in cause number 47004. That modification simply allowed for concurrent drilling of drilling unit boundary wells with the wells within the adjacent drilling units. True and correct copies of the board's orders in 131-151, 47003, and 47004 were collectively submitted as Exhibit B in this cause. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all of the production interest owners in the subject drilling units, to all working interest owners, including unleased owners, in the established drilling units adjacent to the requested drilling units due to the setback reductions, and to the Bureau of Indian Affairs and the Bureau of Land Management, being the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses as disclosed by the relevant agency and county realty records. The record will also reflect that notice was duly published in the Uinta Basin Standard and Vernal Express on June 1st, 2022, in the Deseret News on June 3rd, 2022, and Salt Lake Tribune on June 5th, 2022. Late Friday afternoon, the Division's Counsel filed a response to the request, not necessarily opposing the RAA, the request for agency action, but requesting Uinta Wax to address from where the data used in the drainage calculations were derived. Ms. Roberts and Ms. Hasselback will address that issue in their testimony. With that, I'll commence my examination of Ms. Womack. Ms. Womack, would you please state your name and business address for the record?
Whitney Womack, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what's your current position with Uinta Wax LLC?
I'm a landman with supervision over the area of issue.
All right, would you please put on the record the corporate and bonding status of Uinta Wax Operating LLC?
Uinta Wax Operating is a Delaware limited liability corporation in good standing with its principal place of business in Fort Worth, Texas. It is a successor by name changed to CH4 Finley Operating LLC as of August 1st, 2021. Uinta Wax Operating is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. It is a designated operator on behalf of Uinta Wax LLC.
All right, Ms. Womack, I'm now going to show you what have been marked as exhibits C through G for purposes of this hearing. Do you recognize these exhibits?
Yes, sir.
And were they prepared by you or Uinta Wax personnel with your review and input?
Yes, sir.
Okay, turning your attention to what has been marked as Exhibit C shown on the PowerPoint presentation, please explain to the board what this represents.
Exhibit C is the regional locator map. The subject sections are partially in the boundaries of Brandlett and southeast of Fort Duchesne in Uinta County.
All right, turning your attention now to Exhibit D, please explain to the board what this reflects.
Exhibit D is a plat of subject lands in current long lateral horizontal well DSUs that were established under the 131-151 order. The current setbacks under this order are 330 north-south and 560 east-west, and Uinta Wax is the majority working interest owner, and Uinta Wax Operating is a designated operator on its behalf.
All right. Now I'm going to turn to what we've marked as a demonstrative exhibit. This hasn't been previously submitted to the board, but in light of the division's response, we thought it was appropriate to show you. Explain to the board, first of all, did you prepare this or did Uinta Wax personnel with your review and input?
Yes, sir.
All right, please explain what this shows.
The green shaded area reflects the area subject to the 47003 order as modified by the 47004 order in relation to the subject lands. The subject lands are directly adjacent to the east. Sections 1819 were included in the previous orders, but only as part of a DSU boundary well DSU within sections 13 and 24 3 South 20.
Excuse me a moment. You did not want to enter this in the...
No, this was just for you as a visual representation of what the previous orders showed and the relation to the lands at issue. All right, now turning your attention to Exhibit E, please explain to the board what this shows.
Exhibit E is the proposed DSU boundary well DSU for the 2560 acre unit. We're only asking for the one internal DSU boundary well at this time between the 4 sections, and up to 6 stacked wells sought with the same caveats as provided in the 47003 and 47004 orders.
Now turning your attention to Exhibit F, please explain to the board what this reflects.
Exhibit F is a plat showing all the existing wells in the area at hand. There are only 2 vertical wells currently exist in section 19 for the 131-151 order, each on an associated 80-acre stand-up DSU. The 1280-acre DSU for long lateral horizontal wells overlap.
In other words, it's overlapping. It doesn't convert once a long lateral horizontal well is drilled. Is that correct?
Yes, sir. And there are no long lateral horizontal wells drilled yet on the application land.
All right, finally, turning attention to Exhibit G, would you please explain what this shows?
This is a plat reflecting the area where notice was provided. All production interest owners are in the red lines, and all working interest owners, including unleased owners, within the brown dashed area.
All right, if you would turn your attention now to the certificate of mailing, which is a pleading that I prepared and filed in this matter. Do you have that in front of you?
Yes, sir.
Okay. Do you recognize the names and addresses on that, shown on that certificate?
Yes, sir.
And who are those parties?
The parties and addresses for the parties that are on Exhibit G that were notified in the notification area.
Okay, so those are the parties that within the areas that you testified on Exhibit G?
Yes, sir.
Okay, and how were those names and addresses compiled?
The names and addresses were compiled from UNTOAC's internal land records, including title opinions, a search of BIA, and Uinta County records prior to filing the RAA, and UNTOAC's operating contract land service company.
All right, Mr. Chairman, that concludes my examination of Ms. Womack.
Thank you. Division, do you have questions for this witness?
No questions from the division.
Board members, questions that you would like to ask this witness? Okay, hearing no questions, it's back to you, Mr. McDonald.
Thank you, Chairman Hansen. Ms. Roberts, would you please state your name and business address for the record?
Meredith Roberts, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what is your current position with UNTOAC?
I'm a geologist with UNTOAC working the area at issue.
All right, since this is your first time testifying, would you please outline for the board and the division your education, your work experience, particularly in the Uinta Basin or analogous basins or with unconventional horizontal plays, any certifications or licensures, and if you've been qualified as an expert in front of another state's similar commission?
I have my bachelor's and master's in geology from TCU in Fort Worth. I have 10 years in oil and gas working the Barnett, Marcellus, and Mid-Continent, and nearly 5 years in the Uinta Basin. I have been qualified as an expert in geology by the Oklahoma Corporation Commission in 2015.
All right, Mr. Chairman, based on that testimony and her resume, I would ask that the board recognize Ms. Roberts as an expert in geology for purposes of this cause.
Any concerns, division?
No objection.
Board members? And she so admitted.
Thank you. Ms. Roberts, I'm now going to show you what have been marked as Exhibits H, Revised Exhibit I, and Revised Exhibit J. Do you recognize these exhibits?
Yes.
And were they prepared by you or UNTOAC personnel with your review and input?
Yes, they.
Okay, turning your attention to Exhibit H, please explain to the board what this shows.
Exhibit H is the Brotherson 111B4 type log, which is the same log used to define the lower Green River and Wasatch throughout the basin, including the 131-151 order.
Now, turning your attention to Revised Exhibit I, please explain to the board what this shows.
Revised Exhibit I is an east-west cross-section showing the uniformity through this area, making these attractive zones for long lateral horizontal well development. There's a locator map on the left showing the line of section in relation to the application lands. This cross-section highlights that the lower Green River Wasatch formations constitute one common source of supply in this area, which is consistent with the board's designation of these formations as one pool throughout the Uinta Basin. Labeled along the right side of the cross-section, our current primary horizontal targets are the Castle Peak, Utland Butte, and Wasatch, but Uinta Wax does not want to rule out future development of the other three identified formations.
Now turning your attention to revised Exhibit J, please explain to the board what this shows.
Revised Exhibit J reflects wells in this area with observed stress indicators. The blue arrows on the map are wells with image and sonic logs, and the purple arrows indicate wells with microseismic in this area. The chart at the top is showing the microseismic data from this area and the average fracture half lengths for two specific areas labeled on the map as Area 1 and Area 2, which are 252 and 239 feet respectively. The average fracture orientation from these data points is north 85 degrees west. This is all real data obtained from wells near the subject area, as you can see on the map in relation to our application lands. And I want to point out that this data will carry forward into the next exhibits.
All right. Consequently, in your expert opinion, does the lower Green River Wasatch transitional formations constitute one common source of supply?
Yes.
Is it also your expert opinion that the uniformity of the lower Green River Wasatch members throughout this area make long lateral horizontal wells attractive?
Yes.
Mr. Chairman, that concludes my examination of Ms. Roberts.
Thank you. Division, do you have questions for this witness?
No questions at this time.
Board members? No questions? Seeing none, we'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. Ms. Hasselback, would you please state your name and business address for the record?
Brittany Hasselback, 5128 Apache Plume Road, Suite 300, Fort Worth, Texas, 76109.
And what is your current position with Uinta Wax?
I'm a senior operations engineer currently working this area.
All right, again, since this is your first time testifying in front of the board, would you please outline your education, your work experience, particularly in the Uinta Basin or analogous basins, or with long lateral horizontal plays, and any certifications, licensures, et cetera?
I graduated from the University of Texas with my bachelor's in petroleum engineering in 2012. Since then, I've worked roughly 7.5 years in the Delaware Basin, primarily focused on operations and planning aspects of horizontal development. In late 2019, I transitioned over to Uinta Wax and have been working the Uinta Basin.
All right, Mr. Chairman, based on that testimony and with the resume on the Exhibit A, I would ask that the board recognize Ms. Hasselback as an expert in petroleum engineering for purposes of this cause.
Any comment from the division?
No objection.
No objections? Board members, any objections? She is so recognized as an expert witness for this cause.
Thank you. Ms. Hasselback, I'm now going to show you what have been marked as Exhibits K, L, M, Revised Exhibit N, and Exhibit O. Do you recognize these exhibits?
Yes, sir.
And were they prepared by you or Uinta Wax personnel with your review and input?
Yes, sir.
Okay, turning your attention to Exhibit K, would you please explain to the board what this shows?
Exhibit K is showing, based on the data from revised Exhibit J that Meredith just presented on, that we're using the 85-degree fracture orientation and a larger average fracture half length of 252 feet to be conservative. This is showing that significant areas of resources will be left behind that would be recovered with reduced setbacks without adversely affecting correlative rights.
And that would be the 309-foot and the 308-foot designation on this exhibit. Is that correct?
That is correct.
Okay. Turning your attention now to Exhibit L, would you please explain to the board what this shows?
Exhibit L is using the data provided in revised Exhibit J as well. This exhibit reflects that even with a 100-foot heel-toe setback, there's still a 78-foot buffer to the adjacent land for protection of correlative rights.
Turning your attention now to Exhibit M, would you please explain what this represents?
This exhibit reflects that with a 330-foot perpendicular setback, that there's a 79-foot boundary to adjacent drilling units.
Again, for the protection of correlative rights.
Correct.
Is that correct? Okay.
That is correct.
All right, now turning your attention to revised Exhibit N. This contains a lot of information. Would you please go through this and explain its significance to the board?
The methodology utilized in this exhibit to calculate drainage is pursuant to the directive of division personnel using the Hale and Evers calculation. All of the data utilized in these calculations is from microseismic, PVT, and core data immediately adjacent to the application lands as shown in revised Exhibit J. It is Wax's assertion that there is no drainage occurring beyond the tip of the fracture half length, as shown in the data under column AF in the table at the bottom of this exhibit. As reflected by the BF column, there is no potential adverse impact on adjacent lands with reduced setbacks until between 5 and 10 years when the 100-foot mark is crossed, but it is minimal, with the negligible impact even at 10 years and beyond.
And again, this data is directly in this area, not 25 miles away. Is that correct?
It is correct.
All right. Turning your attention now to Exhibit O, please explain to the board what this outlines.
This exhibit is showing the additional royalties and severance taxes per well that come with additional footage from reduced setbacks. It shows the well economics favor the requested setback reduction.
All right, and also that the setback reductions allow you to place the wells in the best orientation and distance between them for development. Is that correct as well?
That is correct.
All right. Would you please address what is the impact of the requested 330-foot setback between the horizontal and vertical wells? Are you seeing any impact on the vertical wells, or do you anticipate any?
Based on our development to date, nothing has been shown to indicate that there would be any impact or interference with existing vertical wells.
So the 330-foot setback should protect the owners in the vertical wells. Is that correct?
It is correct.
All right. Finally, would you address for the board the need for the boundary unit wells, the internal boundary unit wells that you're requesting?
Drilling unit boundary wells is needed to recover resources that would otherwise be left in the ground in the gap in order to prevent waste.
All right. In your expert opinion, then, the reduction of setbacks and the drilling of up to 6 stacked drilling unit boundary wells are necessary to recover additional resources that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that, in addition, the requested relief will allow the greatest recovery of natural resources with associated greater economic benefit with no or minimal adverse impact on adjacent correlative rights?
Yes.
Mr. Chairman, that concludes my examination of Ms. Hasselback.
Thank you. Division, you have questions for this witness?
Yes, we do. Can you go back to revised Exhibit N? Okay, Ms. Hasselback, so this exhibit demonstrates the drainage calculations. This exhibit caused a little bit of concern from the division because, as was noted in our filing, all of the parameters and data used in this exhibit were recycled from a previous order and request for a subject area that's located about 25 miles away. Could you discuss a little bit more thoroughly where this data came from and how it accurately represents the conditions for the subject lands in this matter?
So all of this data came from microseismic, PVT, and core data that was shown in the revised Exhibit J, I believe, of all those wells in that area. So all of this data is accurate and relevant to the area that we are discussing currently. I was not the engineer over the previous area, so I can't speak on to what data was used in that hearing. But I can guarantee that this data is accurate and it's coming from all of our PVT and microseismic data.
Chairman Hanson, with the board's permission, I'd like for Mr. Ellis Peterson to be able to ask questions directly. Is that acceptable?
Mr. McDonald, any concern about that?
No objection.
Board members, any concerns? Hearing none, please go ahead with that.
If it's okay, Chairman Hanson, I'd like to make one point of clarification for the division.
Sure.
Ms. Hasselback noted on this and that they made these calculations using a methodology as per a directive from the division. The division has never made such a directive. The division has produced technical memos giving examples of ways to calculate, but that was a suggestion. We do not tell the expert witnesses how to do their job. We tell them what we feel is required as evidence.
So what you're saying is it was a suggestion, not a directive?
It absolutely was a suggested method based on some very established references in what is called PetroWiki. It's a public source sponsored by the Society of Petroleum Engineers, and it was a simple methodology that we knew operators could use to justify setbacks based on predicted drainage areas. And this was a methodology that addressed drainage areas for fractured wells. And it's a very simple method. There are other ways to make that same calculation, but it was a suggestion, not a directive.
Mr. McDonald, any?
But this methodology is acceptable to the division, is it not?
It absolutely is.
All right, thank you.
Okay, thank you. Please go ahead.
Yeah, Ms. Hasselback, I have a couple of questions. You mentioned core data. Are the specifically the permeability, is that derived from core data?
Yes, that is.
Did you make any corrections to the core data for relative permeability or anything? Or can you explain to me how you went from the core data, which would be issued in a core report, to this number of 0.0002 millidarcies?
May I defer with counsel on that?
Mr. Chairman, if we could go off the record so I can talk to my client.
Sure, we'll go off the record so they can have this discussion.
Thank you, Mr. Chairman, for that indulgence. We're ready to go back on the record.
Michelle, are you ready? Okay, well, we're back on the record. I guess there was a question that was asked, and is your witness ready to, prepared to answer?
Yes. Ms. Hasselback, are you ready to answer Mr. Peterson's question?
Yes.
Okay, go ahead.
The core data, the 0.0002 for permeability, was just the average taken of the core points.
Okay, thank you. Another question, your porosity, am I right to assume that that information came from log data?
The porosity
Or did
also
it-
came from,
Okay, I stand corrected. So you're saying that,
I'm sorry, she put out that last.
Yeah, Ms. Hasselback, would you please repeat that? The video kind of cut out.
yes, the porosity also came from core data.
all right, thank you. Another question, some of the other factors that go in, parameters used in this calculation, you mentioned it's from PVT data. I just want to clarify. So your viscosity and your compressibility came from PVT data. And of course, I assume you had to calculate your total compressibility using that PVT data. Is that correct?
That is correct.
All right, thank you.
Thank you.
No further questions.
Back to you, Mr. McDonald. Well, I'm sorry. Board members, do you have questions for this witness? Sorry about that. No questions, and back to you, Mr. McDonald.
All right, thank you, Mr. Chairman. That concludes our presentation in chief. At this time, I would like to move for admissions of exhibits A through H, revised exhibits I, revised exhibit J, exhibits K through M, revised exhibit N, and exhibit O.
I have those. Division, do you have any concerns or issues with that?
No objections.
Okay, so admitted.
All right, thank you, Mr. Chairman. I'd like to reserve a little time for rebuttal as necessary, depending on the division's position.
Absolutely. We will turn the time now over to the division.
As noted a few minutes ago, the division picked up on the initial exhibit N as being the exact same as a previous board matter, and that's what caused some concern in this hearing and leading up to this. Having demonstrated that this data does pertain to the subject lands, the division does not oppose the board granting this request and moving forward with what has been requested. Additionally, after reviewing the other area from the previous board order that this data was recycled from, the division notes that these numbers would be conservative rather than kind of a worse situation. It would actually work out, just fine as far as protecting correlative rights. So the division does not object to this data, which has been recycled across different requests, being used in that instance. But the division does note that in the future, the operator making the case should explain where they are getting their data from and why, if data is being recycled across different requests, it pertains and is representative for a specific area if that data is not coming from that area.
Does that sum up your presentation on this matter?
Yes, Chairman Hansen.
Okay, thank you. I think I understand what you said, that going forward, you'd like a little bit more explanation as to the source of data so that it's clear going forward that it applies to the matter at hand.
Particularly when data is being recycled across different areas that are very distinct, both in terms of geography and depth.
Okay, thank you. Board members, do you have questions for the division on this? Please go ahead.
Okay, so since we've talked all about this, I'm very curious as to how far away this core is and the fluid samples that were gathered from this particular well.
Ms. Hasselback, do you want to address that? Is it the areas that were shown on revised exhibit J?
That is correct. It's immediately adjacent.
Okay, so that's a matter of miles rather than tens of miles. Is that
That's
right?
correct.
Okay. Thank you.
Chairman Hanson, may I follow up on that?
Sure.
Mr. Walker, the reason there was concern is that the previous order dealt with areas about 25 miles away, and the data was recycled across those different. So in the previous order, the data was not actually representative of that order, and that's
I'm going to object to that. That's a misrepresentation. Okay, it very well could have applied to that situation. It doesn't necessarily state, like Mr. Gruwell stating, that wasn't applicable to that area.
we can ask an expert on either side whether an area with 1,000 feet difference in depth would have different parameters
No,
surrounding the
I'm not going to
drainage.
argue about that. That's not relevant to this hearing in particular. Your concern was noted, and we will go forward with that, but that's not relevant to this. The data here is clearly relevant to this area.
The division agrees with that.
The data is relevant to this area.
Okay, thank you. Any other questions from the board? Mr. McDonald, would you like to make any comment or rebuttal?
Just in summary with that, the issues that are being brought up here, the division could have easily asked these questions if they had issues with it before in the other hearing. This hearing is clear. This data is here. It's relevant to this. It's the same data that was utilized in the area that you approved, the same relief directly adjacent to it. I think UNOX has clearly established and met their burdens in this matter, and we would ask that the board approve the request as submitted. Thank you.
Division, do you have any further comment or rebuttal to anything that has been discussed?
Just again, we hope that operators will be a little more transparent moving forward when they submit exhibits that have data. The assumption is that that data actually pertains to the area that they're asking to modify spacing. That wasn't the case last month. That is the case this month. There are no issues moving forward from the division's perspective.
Okay, thank you. And I would like to thank the division for submitting their comments and advice. The board appreciates it. Board members, do you have any further comments on this? Go ahead.
Yeah, I guess I would like to make a comment is that with permeability of 0.0002 millidarcies, the correlative rights are extremely well protected. And I don't know that I'm offended by using conservative numbers, but I think I would be more inclined to approve average numbers rather than conservative numbers, because that's tombstone down there. Thank you.
Thank you. Well, I guess at this time, the summations have been made. It's up to the board to make a decision. Would you like to deliberate for a few minutes, or do you feel like there's a motion appropriate this time? Any preferences? Well, it sounds like we don't need to deliberate. If there's a motion that we can entertain.
I'd like to make a motion to approve this application by UNOX.
Is there a second?
Second.
Discussion on the motion? Hearing none. All those in favor, say aye.
Aye.
Any opposed? Hearing none. This matter is approved. This order is approved. Mr. McDonald, I assume you'll prepare the proper documents.
Certainly, Mr. Chairman, and I'll make sure Division's Counsel reviews it too.
Thank you. And to both parties, thank you very much. I know this was an interesting matter for us and appreciate the explanations. So we will move on to the next agenda item.
Mr. Chairman, could I ask for a 5-minute recess just to make sure that my witnesses for the next matter are available?
Absolutely.
All right, thank you.
We'll go off the record for a few moments here. next item is actually,
Oh, no, I guess you could go to that one, yeah.
All right.
I just want to make sure that the event people are ready.
okay. We go back on the record this one? All right. Paul, can we come back in attendance?
Stand by.
Well, wait a minute. Division, are you ready? Okay, we're not quite ready, so I'm sorry. We won't go back on the record. But we will be discussing the formal rulemaking matter.
I didn't give her a link to do that.
We should be done pretty early.
Yeah, really. Going fast. Can never tell with these.
Sometimes I think it's going to be over by noon and it's 5. Did you have a long day?
No, I think we were done by here.
Okay.
So you guys are set, okay. They've got the rulemaking matter, actually short. But just, what, yeah, and then make sure you turn on your camera and sound check. Let's get started.
Tasha, just let us know when you're ready.
Could I have a quick sound check with our remote witness? And also, if we could have your camera activated, please?
Yes, sir. Can you hear me?
If you're extremely quiet on the microphone, we do have good camera. By any chance, can you move the microphone closer to you?
May have to. Can you hear me better right here?
Yes, yes. The closer you're getting to, I assume the camera, you're
Yeah.
much more intelligible.
We'll sit right here at the front of the table then.
Wonderful. Thank you, sir.
Thank you.
Chairman, technically, we are good to proceed when you're ready to reconvene.
Oh.
There it is now.
Yeah.
Hey, Paul, can you see my presentation?
Negative on presentation. Chairman, we're going to need another minute here.
Yeah, just to be clear, we're going to do the tar sands rulemaking matter first before we go on to Aventus.
Hopefully I'll be like 5 minutes. I don't know why it would work for you and not for me.
You still doing consulting then?
Actually, I'm a part-time
Oh.
employee. Want to make sure I get paid.
It is hard.
Okay.
Yeah. I don't know, the emotional is right term. There's a lot of adjustments to, not being the guy.
Yeah.
And also, not having it.
All the meetings and everything's.
Yeah.
That's
All
hard
this
to,
free time. Every day's a Saturday. It's hard to get used to.
It is hard to do.
that is hard to give up that feeling of importance of being the
Yeah,
guy or the
control,
gal.
you know?
Yes.
Come to for recommendations and things. You've been replaced.
How can they continue with
I did some consulting work at Boron in California last week, and I got done and I had my closeout meeting, and all it was the technical people. I've known, where's the mine manager? I always present to the mine manager.
This is me. Oh,
I didn't like it.
I know it's hard to step back, let someone else take over.
Mr. Chairman, thanks for your patience on that technical issue. We're ready to proceed when you're ready.
Okay, thank you. What I'll probably do is when we go back on the record, I'll just read the docket item and turn the time over to Natasha. So, if you're ready, Paul.
We are ready. Thank you, Chair.
Michelle, okay. We will go back on the record. Docket item number 4. Item number 4, docket number 2022-012, cause number 997-01. In the matter of formal rulemaking to amend the oil and gas program rules pertaining to the definition of oil and crude oil for tar sand operations resulting from Senate Bill 146. We'll turn the time over to the division. Natasha?
Hi, I'm Natasha Baliff. I'm the Legislative and Policy Coordinator for the division. That description that you just gave will basically, I'm just going to repeat that basically. So we're coming before you to ask for approval from the board to begin formal rulemaking for the tar sands rulemaking. To recap, Senate Bill 146, titled Oil, Gas, and Mining Amendments, was presented in the 2022 general legislative session. This clarified that in situ oil sands productions will be regulated by the oil and gas program, and the bill became effective on May 4th, 2022. And within that, we are required to complete appropriate rulemaking within 180 days of the effective date, which is October 31st. Kind of a rulemaking timeline, just so you guys know what we're proposing. So today, June 22nd, the board would approve language for formal rulemaking to commence. After, if you guys do approve, I will be filing the form with the Office of Administrative Rules before July 1st. And on July 15th, the rule will be published in the Utah Bulletin, and that begins the public comment period. The public comment period would close on August 14th, and I would be bringing this back to you at the August 24th board meeting. And as long as the comments don't result in any changes to the language, we'd be asking the board to grant a notice of effective date. And then just so you guys can see, this is the only change. This is within the R649-1 section of the rules, and that just deals with definitions. And this mirrors what the statute change was. So I'll give you guys a couple minutes to look over that. Again, we only changed the definition of crude oil and oil and gas. And if you guys have any questions, feel free to ask. And oops.
Board members, do you have questions for Natasha? Certainly, go ahead, Mr. Borden.
This is a bit of a question and a comment. Reading through this, it seems very clear it's specific to production from a wellhead. So this would clearly exclude open pit mining, surface mining, as is occurring like at the tar sands up in Alberta and at the Baskin tar sands, right?
Yeah, the intention was that if it's liquid that comes out of the wellhead, that would be applied to this, but anything else is not applied to the oil and gas program.
Thank you.
Okay, so since we're talking about Athabasca, they have a methodology there, steam enhanced recovery. So this would apply to steam enhanced recovery.
I
then.
believe so, yeah.
Okay, thank you.
Any other questions, board members? Back to you.
I just need approval from the board to go ahead and commence formal rulemaking.
A question for you, Mr. Lyons. Do we need a motion? I'm sorry, I should know the answer.
Yeah, in the past we have had
Yeah, that's
a
what I
motion
thought.
for it, yeah.
Okay. All right, thank you. Well, board members, if there's no further questions and you feel like you can approve a motion for the division to move ahead with the formal rulemaking, we would entertain a motion at this time. Anybody like to make that motion?
I move that we approve the request for formal rulemaking.
Is there a second?
Second.
Any
Yes.
discussion? Hearing none. All those in favor say aye.
Aye.
Those opposed? Hearing no opposition. Division, I think you have the board's approval to move forward with the rulemaking.
Awesome, thank you so much. I will get that form filed.
Thank you. Are you ready, Mr. McDonald?
I am. Jordan, could you please turn on there we go. Witnesses are ready.
All right, I will read the next item into the record. Item number 5 is docket number 2022-013, cause number 472-01 in the matter of the request for agency action of Oventive USA Inc. for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting owners in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River. I'm not going to go on anymore. I think we know what's ahead of us. We'll turn the time over to you, Mr. McDonald.
Thank you, Mr. Chairman. Testifying on behalf of the petitioner Ovintiv USA Inc. today are Mr. Jordan Lear. Jordan, would you please wave? And Mr. Brian Bolding. Brian, Byram, would you please wave? Okay. Mr. Lear is the senior land negotiator, and Mr. Bolding is the development reservoir engineering manager of USA Inc. I ask that both witnesses be sworn in at this time.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Were you able to hear
Sound
it?
okay? All right. If you guys just make sure you speak a little bit louder so we can hear, okay?
Okay.
Mr. Chairman, the resume of both witnesses were collectively submitted as Exhibit A. If separately asked, both would verify the contents of the resume are true and correct. Mr. Lear is testifying before the board for the first time and will provide both factual and expert testimony. I will qualify him as an expert in petroleum land management at the commencement of his testimony. Mr. Bolding has previously been recognized by the board as an expert in reservoir engineering in cause numbers 600-02, 600-03, and 130-07. Presuming the division has no objection, I ask that the board recognize Mr. Bolding as an expert in petroleum engineering for purposes of this cause.
Division?
No objection.
Board members? Well, I think that it's unanimous. He is recognized as an expert witness for this matter.
Thank you, Mr. Chairman. And again, I will be moving for admission of our exhibits at the end of our presentation in chief.
Thank you. Yes.
Board members, this cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch Formation, comprised of the entirety of Section 11, 3 South, 1 West in Uena County. The drilling unit was established by the board order entered in cause number 139-90 in 2012. Under this order, up to 4 wells on the drilling unit are authorized, whether vertical, directional, or short lateral horizontal. The 139-90 order was modified by the board's order in cause number 139-134 in 2015, which instead established a drilling unit comprised of adjacent Section 2 and Section 11, but it only becomes effective upon the drilling of the first long lateral horizontal well. No such wells have been drilled. As a consequence, the 139-90 order still remains in effect. True and correct copies of the 139-90 and the 139-134 orders were collectively submitted as Exhibit B in this cause. Although originally permitted as a long lateral horizontal well, Ovintiv instead drilled the Wyasket 13-12 3-1-11-41H well, which I'm just going to refer to as the Wyasket well, within Section 11 as a short lateral horizontal well, pursuant to the 139-90 order in 2018, completing it as a producing oil well with first production from the Castle Peak Formation on November 29, 2018. As outlined in the request filed in this matter, the majority of oil and gas in Section 11 is owned by the state of Utah, the Ute Indian Tribe, and Indian Alaatees. The oil and gas in only 213 1/3 acre of the 640 acres are privately owned. As originally alleged in the request, Ron Olikers owned an unleased 50% interest in 120 acres, representing 9.375% of the drilling unit. He was provided an opportunity to lease or participate in the Wyasket well, both under the old and new compulsory pooling regulations, but never timely responded. As such, Ovintiv originally sought to compulsory pool his interest. However, since the filing of the request, Mr. Olikers sold his interest to Ovintiv, thereby eliminating the need to compulsory pool his significant interest. Although Ovintiv believed that it now has all of the oil and gas under lease or control and is pooled and communitized the same, some of the fee leases were granted by parties claiming buy-through or under the estates of deceased parties for whom no confirmatory Utah probate proceedings were initiated, or if they were initiated, they've been incomplete as to proper distribution of the mineral interest in Section 11. As such, there's a possibility that there may be some unknown party out there claiming buy-through under these estates who is unleased and not pooled. Consequently, as to such potential unknown heirs or successors, pursuant to an order issued by the board, a notice of opportunity to participate relating to the Wyasket well, as required under Utah Administrative Code Rule R 649-29A, was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to that notice or otherwise has tendered his or her share of the cost of the well. The proof of that publication was submitted as Exhibit G after the filing deadline, but as I understand, the board had that in its record. Ovintiv therefore seeks to have these unknown parties to be compulsory pooled and also declared as non-consenting owners. It's important to point out that that's a contingent situation if and when any such person should be identified or comes forward later. As none of the unknown timely filed a response to the request pursuant to Utah Administrative Code Rules R 649-104-150 and R 641-108-400, I'll move to enter an order of default against them. As to the non-consenting parties, if ever discovered, Ovintiv seeks the imposition of a 300% risk compensation award and the imposition of the terms of a joint operating agreement materially the same as signed by the other working interest owner in the area, which terms have been previously deemed reasonable by the board in other compulsory pooling hearings. During the recoupment period, such owners, if ever discovered, will be entitled to an 18.917786% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of the Wyasket well. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations R 649-2-8A and R 649-2-9A. A copy of the request was mailed to all the production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and to the Bureau of Indian Affairs and the School and Institutional Trust Lands Administration as the governmental agencies having supervisory authority over the tribal and allotted lands and the state lease. In addition to the published notice of opportunity to participate in the Uinta Basin Standard previously referenced, notice of the filing of the request and the hearing was also published in the Uinta Basin Standard and Vernal Express on June 1st, 2022, the Deseret News on June 3rd, 2022, and the Salt Lake Tribune on June 5th, 2022. No other objections or responses to the request were timely filed, and the division has elected not to file a staff memorandum in this matter. This time, I'll commence my examination of Mr. Lear. Mr. Lear, would you please state your name and business address for the record?
Jordan Lair. The business address is 4 Waterway Square Place Suite 100, The Woodlands, Texas 77380.
Michelle, are you picking that up okay? All right. What is your current position with Ovintiv?
The senior land negotiator responsible for this drilling unit.
All right, since this is your first time testifying in front of the board, would you please outline your education, your work experience, particularly in this basin, and in particular with joint operating agreements and the AAPL Form 610 joint operating agreement, and if you've been any other coursework that you've done with relations to joint operating agreements, or if you've been recognized as an expert in in front of other commissions.
Sure. I graduated from Texas Tech University with a degree in energy commerce in 2011 and have since been employed in the industry as a landman for various companies. My experience includes several unconventional basins, being the Eagle Ford in Texas, the Bakken in North Dakota, and more recently, the Uinta Basin here in Utah. During my time as a landman, I have analyzed, negotiated, and administered several JOAs and have attended 2 AAPL courses related to operating agreements, being the Model Form Operating Agreement course and the Intro to the Model Form 610 2015 JOA course. And I also currently hold a RPL from the AAPL, so I'm a registered professional landman.
All right, thank you, Mr. Chairman. With that testimony and Mr. Lur's resume, I would ask that the board recognize him as an expert in petroleum land management for purposes of this cause.
Any concern, division?
No objections.
Any objection, board members? Hearing none, he's so noted that he is an expert witness for this cause.
Thank you. Mr. Lur, would you please outline the corporate and bonding status of Oventive for the record?
Oventive USA Incorporated is a Delaware corporation in good standing with its principal place of business for the Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production Incorporated.
All right, I'm going to show you now what have been marked as Exhibits C and D for purposes of this hearing. Do you recognize these exhibits?
Yes, sir.
Were they prepared by you or Oventive personnel with your review and input?
Yes.
Okay, turning your attention to Exhibit C, would you please explain to the board what this reflects?
Exhibit C is just a regional location plat showing this section. Obviously, it's in the western part of Uinta County, just due south of Roosevelt and Ballard City.
Now turning your attention to Exhibit D, please explain to the board what this reflects.
Exhibit D is a plat of the mineral tracts within Section 11, of which there are 8 tracts, and it also shows the location of the Wyasket well we're discussing within the section. The Wyasket well was originally proposed as a long lateral well, as Mr. McDonald mentioned, but due to management decisions was changed to a short lateral well, so it's entirely contained within Section 11. It was spud on August 29th, 2018, and completed as a producing oil well on November 29th, 2018, with productive intervals in the Castle Peak Formation. As I said, there's 8 mineral tracts. However, only 213 1/3 acres are owned in fee, being in tracts 1, 2, 3, and an undivided 2/3 portion of tract 5. Again, as Mr. McDonald had stated, Oventive believes that all are believed to be leased by Oventive or Uinta Wax, except for 50% of tract 3, which was owned by Ron Olkers and unleased until 2 weeks ago. And as we've discussed, Oventive has since purchased that interest. Oventive and UWAX's predecessors executed a joint operating agreement covering Section 11. Its terms contractually govern the well, elections, including the election made on the Wyasket well here. Their predecessors also executed pooling declarations along with SITLA, and together with the tribe and UDC executed a communitization agreement, which has been approved by the BIA, pooling the leases. As Mr. McDonald again mentioned, there are several lessors that claim title in tract 3 through one or more of the estates of the following deceased record mineral interest owners. Mr. A.N. Johnson, aka Alfred Nathaniel Johnson, Mr. Lamar Johnson, Mr. Norman Etheridge Johnson, Mrs. Therma Mae Johnson, Mrs. Edith K. Johnson, also known as Edith K. Gregory, Mr. Norval Rich Johnson, and Mr. Orlin L. Johnson. For all those estates, no Utah probate has been initiated, or if filed, they are incomplete in that they have been in that there has been no proper distribution made to the heirs or devisees. Although based on heirship affidavits and other inquiries and research done by Oventive's lease broker, Oventive believes it or UWAX has leased all of their successors. However, without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore Oventive seeks to compulsory pool their interests.
I'm going to refer you now to Exhibit G. That's the proof of publication to these unknown parties. Did Oventive ever receive any response to that published notice?
No, sir.
Okay. Now I'm going to refer the board and you to what have been marked as Exhibits E and F. They're very long documents. On the PowerPoint, I'm only going to highlight a portion, the relevant portion of those documents. Do you recognize this Exhibit E and F, these relevant portions that I'm showing? Oh,
Yes,
excuse
sir.
me, right there. Do you recognize those?
Yes.
Are those official business records of Oventive?
Yes, they are.
And you've reviewed them yourself, is correct?
Correct.
Okay, can you explain what Exhibit E and F were, and then also in particular these portions shown on the PowerPoint?
E and F were the notices of opportunity to participate furnished to Mr. Ron Olkers. The now relevant portions are obviously the AFEs that were enclosed there, being the estimates of cost for the Wyasket well.
All right, and this is going to be relevant as to the risks that were involved and also the estimate as relation to actual costs. Is that correct?
Correct, and Mr. Bowling will further testify to that upcoming. It's important to state as well, although not shown in these exhibits, that the Wyasket well has reached 100% payout as of the end of March 2021, but has yet to reach 300% payout.
All right. Now I'm going to turn your attention to Exhibit H, which is the joint operating agreement. Again, it's a very thick document, so I'm going to only point to certain highlighted portions. Was that joint operating agreement prepared by you or Oventive personnel with your review and input?
Yes, it was.
Okay. Kind of outline for the board what about the joint operating agreement and its provisions, and then we'll highlight these portions that are shown on the PowerPoint.
The form utilized was a standard industry form supplied by the American Association of Professional Landmen, AAPL. It's Form 610, and this is the 1989 version with modifications that have been made for horizontal drilling. The terms and conditions contained therein including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units. Oventive has prepared identical terms for other drilling units it has operated and has agreed to such terms and other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, EP Energy, and other major Uinta Basin operators.
All right, I'm going to turn your attention now to the page that's shown on the PowerPoint in the yellow portions and explain the significance of that to the board.
These are the penalties proposed. It's 100% on all surface equipment outside of the wellhead and 300% on the risks of the well as far as those costs. So it's 100%, 300% provided.
All right, and again, that the 100% has already been reached in this well. Is that correct?
Correct. Yes, sir.
Okay. Now turning your attention to the second page of the highlighted portion, outline for the board what this shows.
That is the accounting procedure under the proposed JOA. And the highlighted portion there, is the interest rate set on delinquent payments under the accounting procedure, which is 3%. The interest rate at the prime rate sets the interest rate at the prime rate and published in the Wall Street Journal plus 3%, fair compensation, and to encourage timely payment of chargeable costs and expenses. So again, it's what the interest rate would be to a party that is delinquent under the accounting procedure.
All right, and is this accounting procedure, it's attached as Exhibit C to the joint operating agreement. Is this pretty standard form too that most operators accept?
Yes, sir.
Okay, and that's throughout the Uinta Basin, is that correct?
That's correct.
All right. Finally, turning your attention to the last page that's highlighted here, outline for the board what this is.
That is another portion of the accounting procedure dealing with the overhead charges that have been proposed on this well. Obviously, it states therein that a drilling well would be, sorry, I have a little bit of a hard time, just over $9,000 a month for a drilling well, and 10% of that amount for a producing well.
All right, and just for the board's information and the record, the interest rate that Mr. Lair testified to is on page C3 of that accounting procedure, and the overhead charges are on page C9. So if you're looking for them, I apologize, I should have said that up front. All right, Mr. Lair, in your expert opinion then, are the terms and conditions of the proposed joint operating agreement fair and reasonable and consistent with those commonly accepted by industry, and in particular the Uinta Basin with respect to horizontal well operations?
Yes, they are.
All right. Reminding the board, Utah Code Annotated Section 40-6-6.5, subparagraphs 6 and 8, provide that a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period. With respect to that, I'm going to direct your attention, Mr. Lear, now to what has been marked as Exhibit I. Do you recognize that exhibit?
Yes, I do.
And was that prepared by you?
Yes, it was.
All right, would you please outline what this shows?
This is the calculation of the average weighted landowner royalty. So it shows all the leases that were obtained prior to the spud of this well, and the weighted average of the net acres that are covered by each lease times the divided by the total number of fee acres times the royalty.
And what was that average come out to be?
The average weighted fee royalty in Section 11 came out to be 18.917786%.
All right, just as a reminder to the board, the statute does not include state, tribal, or allotted lease royalty. This is strictly apples to apples with fee royalty. All right, finally, Mr. Lear, turning your attention, do you have in front of you the certificate and supplemental certificates of mailing which my office prepared in front of you?
I do.
All right. Do you recognize the names and addresses shown on there?
I do.
And who are those parties?
Those are the parties within the, those are the parties within the spacing unit that were all noticed.
And how were those names and addresses derived or compiled from?
They are from Oveniv's records based on production from the pay deck, supplemented with the current records in Uinta County.
All right. And for the board's information, we submitted an Exhibit Z, which showed the return receipt to Mr. Olikers, but since he's now sold his interest to Oviniv, it's not needed anymore. With that, Mr. Chairman, that concludes my examination of Mr. Lear.
Okay, thank you. Division?
No questions.
Board members, any questions for this witness?
Was the Oventive purchase of the Olker interest back to first production? Is there any money that is due, Mr. Olker, from 2018 to current?
No, it was effective back to actually prior to the spud of this well.
Okay. And from your records, you believe now it is 100% leased unless someone comes forward as an heir?
Correct.
Thank you.
We own the minerals. We haven't actually leased it to ourselves, but as far as Oveniv having control over that interest for the purposes of development, yes, that's my understanding.
Thank you.
Could I have a clarification again? Now, Oventive does not have any other parties that are working interests in this well. Does Oventive have just 100%?
As kind of noted in the RAA, Uinta Wax is a working interest owner in the unit. However, their predecessor went non-consent as to this well. So currently, we're in an APO status, or I'm sorry, we're in a BPO status on this well where they'll come back in after the 300% payout has been reached.
Okay, you've been referring to the operating agreement as a proposed operating agreement. I assume it's already in place then with the predecessor of Uinta Wax. Is that correct?
Yes, sir. We have a separate operating agreement with Uinta Wax covering this section.
Okay, so that's separate from this proposed operating agreement.
Yes, sir.
Are there significant differences between the two operating agreements as far as penalties?
No, sir. They're exactly the same.
Okay, thank you very much.
Any other question, board members? Hearing none, we'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. Mr. Bolding, would you please state your name and business address for the record?
Yes, my name is Byron Bolding. I'm at 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
Or what's your current position with Oventive?
My current position is the Development Reservoir Engineering Manager that covers the Uinta Basin.
All right, turning your attention now to Exhibit J. Do you recognize this exhibit?
Yes.
Was it prepared by you or with your input and review?
Yes.
All right, would you please explain to the board what this shows?
So this shows all the costs incurred to date from the drilling of the Wyasket 41H well. Includes both the capital expense at the time of drilling the well and the operating expense of the well since it came online in November of 2018.
And how does this compare to the original AFEs that were shown as Exhibit C and F, parts of Exhibit C and F?
It is very much in line. It was within 2.5% of the AFE amount.
All right, and then in your expert opinion then, were the costs fair, reasonable, and necessary?
Yes.
And is the well deemed economically feasible as that term was used in the board spacing order to drill?
Yes.
All right. Please outline for the board, what is Oventive's estimate on the plugging and abandonment costs for this well?
Our current estimate is about $75,000, and that is consistent with a lot of our P&A charges in the Uinta Basin. We haven't done a well of this depth here recently, but that is in line with our expectations. Is a little bit deeper than a bunch of recent AFE charges for P&A work we have done a little bit further south of here.
And that's based on 100% working interest. In other words, that's the full cost for the P&A, correct?
Correct.
Right. I'm going to show you now what have been marked as Exhibits K and L for purposes of this hearing. Do you recognize these exhibits?
Yes.
Were they prepared by you or with your review and input?
Yes.
All right, turning your attention to Exhibit K, would you please explain to the board what this shows?
So Exhibit K outlines the 3 producing Castle Peak wells in the area shown in the gray boxes near where the Wyasket wells were drilled in 2018. These 3 wells had different production history at the time these wells were drilled, varying from 9 months till about 34 months.
All right, and go ahead.
This also kind of shows some of the risk and uncertainty of drilling the Wyasket wells. This was the furthest east at the time the company had drilled on wells, and it was pushing the understanding of what the wells could deliver. And there was some varying production results amongst the 3 existing wells at the time the well was spud.
So from an internal decision making from Oventive, there was definitely some risks with this well at the time of spud.
That's correct.
Because it was a Castle Peak well.
Yes.
All right. Turning your attention to Exhibit L, this is just explain what this shows and kind of go through each bullet point?
So this explains the risk identified at the time prior to the drilling of this well and the actual risk we saw while drilling the Wyasket well. So I'll start at the top. The pre-spud risk outlines some of the drilling and operational challenges the team had identified, including the higher clay content in the Upper Castle Peak Formation, which has the potential to collapse and stick drill pipe and casing. Is a heterogeneous siliciclastic rock. It makes geosteering interpretations difficult with high execution risk, particularly at the time not having many wells in this horizon. Drilling with water-based fluids adds risk, again, related to the clays if they were to swell, and that adds associated operational risk as well. And in summary of the risk identified is the mechanical instability risk. We did have to run an extra string of intermediate casing set at the curve at the landing point to minimize the risk of drilling the lateral. When we actually drilled the well, we actually noted both the operational challenges of the Wyasket 41H and the adjacent well drilled in the section next to it about 1,300 feet away in the Wyasket 47H. The well of subject is the Wyasket 41H. We did have a sidetrack up hole due to twisting off a bit and left it in the hole. So we did have an issue there. Unfortunately, it did not cause much of an overrun on the AFE costs as we outlined previously. On the adjacent well on the Wyasket 47H and the unit to the east there, we did have two side tracks drilling that lateral due to hole stability issues, and that further highlights some of those mechanical instability risks outlined in the pre-spud section on this. The one last thing that Jordan had already testified to earlier is at one point in time, this was planned as a long lateral, and it was cut short to stay within the section as a 5,000-foot lateral due to capital constraints as well in late 2018.
All right, in your expert opinion then, for those reasons, do you feel that a 300% risk assessment award was justified?
Yes.
All right. That concludes my examination of Mr. Bolding, Mr. Chairman.
Thank you. Division, any questions of this witness?
No questions.
Board members, questions? Seeing none, we'll turn it back over to you, Mr. McDonald.
Thank you, Mr. Chairman. At this time, I would move for admission of exhibits A through D, the AFE that was included as parts of exhibits E and F, and exhibits G through L.
So admitted.
Thank you. Members of the board, again, keep in mind, this is just a contingent situation if and when any of these errors pop out of the woodwork. And I've had enough experience, and I know Ms. Garrison's had enough experience where you think you have everybody leased, and then all of a sudden there's a stepchild or some third related cousin that shows up that is entitled to title under the intestacy laws or whatever. So this is a contingent situation to take care of that. I believe we've established that Ovintiv has met all of the statutory and regulatory requirements for the compulsory pooling of those interests. And we would ask that the board approve the request as submitted. Thank you.
Thank you. Division,
No objection.
any presentation on part of the division?
Not in this matter.
Okay. Board members, would you like to deliberate on this, or do you feel you have enough information, have a decision to be made now? If everybody's okay with the decision at this point, well, this has been easy. I'll entertain a motion.
I move that we approve the request for agency action as submitted.
I second.
Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Opposed? No, it's unanimous. The motion is passed. Mr. McDonald, will you prepare the documents?
Certainly, Mr. Chairman. Thank you.
Thank you. Well, that is the last matter before the board today. So we will entertain a motion to adjourn.
Make a motion to adjourn?
All those in favor say aye.
Aye.
We're adjourned. Thank you.